Hello, everyone, and welcome again to Criminal Law 1, Constitutional Criminal Procedure. Today, we're discussing preliminary hearings, grand juries, arraignments, and pretrial motions. But first, let's begin with a review of what we discussed during our last lecture. So we discussed specifically the right to counsel and public defenders. So the right to counsel attaches when, quote, formal criminal proceedings are initiated. It attaches at all critical stages of the prosecution. Now, critical stages have been defined by the Supreme Court as those that affect the ability to present a defense. So this happens at the arraignment and the initial appearance, preliminary hearings, which we'll discuss today, post-indictment lineups, custodial interrogation, plea bargaining, trial, and sentencing. Now, how do we determine whether or not somebody qualifies for a public defender? It depends on the state, right? So states set different rules in terms of if you qualify for a public defender or how much you have to supplement your own defense with a public defender. States are kind of all over the place, and the Supreme Court really hasn't weighed in and said, this is the definitive standard. That being said, at the federal level, you could honestly be a multimillionaire and still probably qualify for a federal public defender. And that's how liberally they interpret the constitutional requirement to counsel. So maybe one day we'll see the Supreme Court weigh in and say that states have to use the same standards as the feds, or maybe set some kind of bright line. But right now, there's not. It depends state by state. And it's often tied politically to the state. So depending on how a state leans in terms of its political standing, in terms of if it's Democrat, Republican, or purple state, we see different levels of what qualifies for public defender and what doesn't. So remember, when we talk about the public defender or even attorneys, even private defense attorneys in general, under the Constitution, you have the right to not only counsel, but you have the right to effective counsel. Now, the Supreme Court has interpreted effective counsel to mean the but-for test, right? So in other words, in criminal proceedings, if you want to say that your lawyer was ineffective and thus you were denied the right to effective assistance of counsel, it's on you to show that but for your attorney failing to do what their job was to do, you would not have been convicted. Right? That's a really hard standard, because if you could prove that you wouldn't have been convicted, you probably wouldn't have gone past the probable cause determination, and especially the reason without determination. So it's a very, very close to impossible standard. In civil cases, you have to show actual innocence, which again is a very impossible standard. So this right to effective counsel but-for test is a very high threshold, and it's actually higher than civil right to counsel. So that's just something to kind of keep in mind, that the right to counsel, we say it exists, but it's very much on the fringe. Now, you also have a right to represent yourself, right? And we call this pro se. Now, this right is not unlimited, right? So we have to make sure that you are basically cognizant of the charges and understand what the sentences can be, and then you can represent yourself. However, if you start causing disturbances and outbursts and all that kind of stuff, the court will step in and make a lawyer appear for you. To that end, Um, a lot of courts appoint standby counsel. So if you decide to go pro se and you go to trial, they will have a public defender in the room throughout the trial to tag in any time that you need them to, right? So if you get halfway through a trial and you're representing yourself and you're like, oh, I don't know what I'm doing, you can ask for an attorney at any point. And then the public defender would just come up and they wouldn't have a new trial, but the public defender would start from that point moving forward. So that's just a general overview of the right to counsel and public defenders. So let's talk about judicial determinations of probable cause. So in order to proceed to trial under the Federal Rules of Criminal Procedure, the prosecutor must establish probable cause by one of two mechanisms, largely depending on how the arrest was conducted. So either a preliminary hearing or a grand jury. Now, something to keep in mind as we're going through this is the federal rules, right? States have their own rules, but largely states' rules mirror the federal rules. So again, two ways that we determine probable cause, depending on the arrest, is preliminary hearing or a grand jury. So the preliminary hearing, and if you click this link, you can go to the actual rule and read the rule if you'd like to. Basically says it's in place for arrests in which the prosecutor files an information, right? So this is where maybe an arrest was conducted without a warrant, a felony arrest in public, whatever it was, a lawfully conducted arrest in which the prosecutor says, we didn't have time for a grand jury. Here is what we expect to prove beyond reasonable doubt. These are the charges. Here's the evidence supporting it, etc. Right? Now, the preliminary hearing is preferred by defense attorneys. The reason the preliminary hearing is preferred by defense attorneys is during the preliminary hearing, the prosecution has to prove to the court that probable cause exists, that one, a crime was committed, and two, you are the person who committed the crime. Now, in order to prove this, the prosecution has to call witnesses, right? So it's almost kind of like a mini trial. That being said, the defense does not get to call witnesses. Only the prosecution does. But the defense attorney has the right to cross-examine any witnesses during the preliminary hearing. So what does this mean kind of in grand perspective? It means that, and this is why defense attorneys prefer the preliminary hearing, you basically get a sneak peek at what the prosecution's case is, right? You know what witnesses they're going to call, what the witnesses are going to say, how they respond on cross-examination, etc. So you kind of get like a trial run to help inform how you proceed with the trial. Right, so preliminary hearing, it's a court hearing, almost like a mini trial. Again, defense does not get to call witnesses, but they do get to cross-examine prosecution witnesses. Now, the less preferred method is the grand jury. Now, depending on if it's a state or if it's federal level, generally speaking, a grand jury consists of 16 to 23 jurors, right? So much more than we think about when we think of pettit juries, right, which we're talking is usually 12, but it can be less. So this is where the prosecutor files a complaint or when there's otherwise convened by the prosecutor, right? So basically the idea here is the prosecution goes behind closed doors and conducts a secret proceeding in which the prosecutor calls witnesses, in front of the jurors, the grand jurors. The only people out in the room are the prosecutor, a witness, and the grand jurors. And they present their evidence, and then the grand jurors decide whether or not to indict, right? So in other words, whether or not there's probable cause. It's called at this point a true bill, and it later gets referred to as being an indictment. Now, again, this is where somebody is not been immediately arrested. This is they're trying to convene enough information to proceed to a trial. Now, obviously, defense attorneys do not like this because, as I said before, the only people allowed in the grand jury room are the grand jurors, the prosecutor, and a witness. Now, here's an interesting question. Can the grand jury, which does have subpoena power, subpoena somebody they're investigating, otherwise known as a target, to testify? The answer is absolutely. Right? Now, you can invoke Fifth Amendment rights at certain points, but more so, what happens is you get a lawyer. Your lawyer waits out in the hall, and this is true for any witness. They can have a lawyer. The lawyer has to wait out in the hall. You get asked a question by the prosecutor. You get up, you go out into the hallway, you talk to your lawyer about the question and what the answer should be. You come back in and you give your answer. And you do this every single time there's a question asked. Right? So grand jury proceedings can last a very long time. Otherwise, most of them actually last very short amounts of time, done within maybe 15, 30 minutes. Now, grand juries, as I said before, they constitute 16 to 23 jurors, right? That's much larger than what we consider the petit jury to be. Now, they don't have to prove anything beyond a reasonable doubt, right? Here, we're just trying to find probable cause. Is it more likely than not that a crime occurred? And is it more likely than not that you committed the crime? Now, whereas petit juries, which are trial juries, right, they serve for maybe a week at a trial. Grand juries convene for 18 months and are subject to extensions. So grand juries, when they convene, right, it's always better to get on a petit jury than a grand jury. Grand juries, when they convene, they don't just hear one case and then it's over. Right? They hear a multitude of cases, several a day, for 18 months. Now, this is subject to extensions. So if there's a really complicated case, or we're talking something involving RICO, we can always extend the time frame. The judge has to approve it, but it can be extended. Now, grand jurors do get paid very minimally, just like petit juries do, anywhere from $15 to $50 a day. Grand juries will hear several cases a day, and grand juries are the prosecutor's playground, right? So almost always while theoretically it's a check on the prosecutor, in reality, the grand jury is the prosecutor's playground, right? So a famous New York jurist once stated that a grand jury would indict a ham sandwich. And that's very much true. Generally speaking, grand juries always follow the prosecutor's recommendation to indict. Now, that's why when we see grand juries convening and not indicting, that the legal community kind of tenses up and suggests that the prosecutor encouraged them not to indict, because the grand jury is just going to follow what the prosecutor says, right? The grand jury, all they hear is one witness, the witnesses for the prosecution. They don't get cross-examined or anything like that, right? So grand jurors also get tired, and so they just indict. So when a grand jury does not indict, it does suggest that the prosecutor maybe recommended against an indictment, or the prosecutor didn't put on a good case intentionally so that the grand jury would not indict. Now, hearkening back to civil unrest when it comes to policing, if you all recall Ferguson, Missouri, where a police officer shot and killed a teenager who was suspected of robbing a convenience store. And the question was, did he punch the officer or whatever? The grand jury did not indict. Now, for most people, like, this is like, okay, there wasn't enough evidence. For the legal community, people in the legal community kind of just tightened up, right? Because the grand jury is generally going to do what the prosecutor tells them to do. So if the prosecutor says, we recommend not indicting, issuing a no bill, then that's what they're going to do, right? Because the grand jury, generally speaking, they don't care, right? Imagine, it's a pain to serve on a jury for a week. Imagine having to meet every other day for 18 months, subject to extension, so anywhere up to like 24 months, 2 years, hearing case after case after case. At some point, you're just not going to care, right? And so that's why we see such a really big issue when a grand jury does not indict, because we're wondering if the prosecutor slanted it one way to make themselves look good while taking the pressure off of them, right? So they can always say, if they're running for a re-election, well, I went to the grand jury and this is what the grand jury did. They don't have to talk about they recommended it against it. Now, grand juries, like I said, they will generally always vote to indict. And again, if the jury determines probable cause does not exist, it may issue what's called a no bill, right? So this is when the grand jury doesn't indict, it's called a no bill. Now, here's a really interesting caveat. Double jeopardy, right? The prohibition against double jeopardy does not attach to this decision. So let's say that the prosecutor really wants to indict someone. They put on what they think is a good case. And the grand jury, for whatever weird reason, decides not to indict. The prosecutor can dissolve the grand jury, dismiss the grand jury, get a brand new grand jury, and represent the case. And they can do this as many times as it takes in order to get a true bill or an indictment. So this was a point of contention also in the Ferguson, Missouri issue, was the grand jury, which Missouri, they have grand juries sometimes, but usually it's by a complaint or an information. But sometimes they use grand juries. In this case, they decided to use a grand jury instead of the prosecutor filing charges. Now, the grand jury voted for a no bill, right? Which always kind of implicates, what did the prosecutor do? Did they put on their best case, etc. The prosecutor at the time came out and said, well, we can't get another grand jury because double jeopardy attached. That was untrue. Double jeopardy does not attach until at trial, the first witness is sworn. So double jeopardy does not attach. So this means, again, that the prosecutor, if they keep getting no bills, they can keep dissolving the grand jury until they get an indictment. Now, again, they're usually going to get the indictment. So let's talk about the grand jury a little bit more in detail. So in addition to issuing indictments against the target, right? The target is the person that the prosecutor is trying to prove that there is probable cause that the crime occurred and that that person committed the crime. Grand juries have extensive investigatory powers. So they can issue what are called subpoenas ad testificandum or subpoenas duces tecum. So a subpoena ad testificandum is a legal requirement that you come to the grand jury and you testify, right? So testifcandum, testify, those kind of go together. They can also issue subpoenas duces tecum. Now, subpoena duces tecum is a requirement that you present documents or you present some kind of evidence, right, beyond just your testimony. So they can issue these. Now, this power, right, to issue these subpoenas is intensified by the rules and procedures of grand jury investigations, right? So these are all legally enforceable. So if you get a subpoena to testify in front of a grand jury and you don't come on the date and time that you were told to be there, an arrest warrant will be issued for you, even if you're not the target or you're just a witness. An arrest warrant will be issued for you, and they will drag you into the grand jury room in handcuffs, let you testify, and then maybe have to deal with some criminal charges following that, right? So the subpoenas are very, very real. Right, same thing is true for subpoena duces tecum. If you don't present documents that you're supposed to, very bad things are going to happen to you. Now, this power of the grand jury is intensified by the rules and procedures of grand jury investigations, including one, witnesses, which do include targets, do not have a right to counsel, right? So if you are subject to a grand jury investigation, I'll talk about a target letter in a second, and they subpoena you, your lawyer is not allowed in the room and you don't get one appointed for you. You can hire a private one. And again, the prosecutor will ask a question. You can get up, leave, walk into the hallway, consult with your attorney, get advice, and then return and answer the question. Now, obviously, this looks really, really fishy if you do it every single time, or you do it even randomly for a grand jury. So, yeah, even if you're the target, you don't have the right to counsel. Now, grand juries also have the power to award immunity, right? So, specifically, transactional immunity. There's two different types of immunity. One type of immunity basically says you're king for a day. So whatever you say or you testify to, they cannot use against you, right, at a criminal proceeding later on. Another type of immunity is the grand jury says you will not be charged with the crime, right? And obviously you want the second one rather than transactional immunity, or excuse me, rather than the first type of immunity. Now, the rules of evidence, which we'll discuss later, do not apply at the grand jury proceedings. Thus, grand juries can hear evidence from illegal search and seizures, right? Now, if, again, we're talking somebody violates the Constitution and conducting a search or a seizure or what have you, grand juries can still hear that, right? So while it may not be admissible at trial, it is admissible in front of grand juries. Now, it's really not smart on the part of the prosecutor to use illegally obtained evidence because they're not going to be able to use it at trial. So why would you use it here in front of a grand jury, which is almost like a practice run, right, of the trial, one that occurs in private, which the defense doesn't get to see, right? Because you can bet your butt that the defense are going to file a motion to dismiss or a motion to suppress, right? Something along those lines. Now, as I said before, grand jury proceedings occur in private. In fact, a target, so somebody that the grand jury is investigating, will only find out they are under investigation if they are subpoenaed to testify against themselves. Now, if they are subpoenaed to testify, they do have to show up. They may invoke the Fifth Amendment, which looks really suspicious. Now, that being said, targets are usually given a heads up if they're called to testify. If they're not called to testify, we do not tell possible targets anything's going on. We don't want them to run. We don't want them to hide evidence or anything like that, right? But if we are calling a target to testify against him or herself, the grand jury is required to issue what's called a target letter. All right, so in addition to the subpoena, there's an accompanying letter saying you are the subject to an investigation. This is what the proposed charges are, et cetera, et cetera. You may hire an attorney at your own expense, so on and so forth. And so it puts the person on notice that they're not just a witness, the grand jury's coming after them. Now, this is very, very rare that this occurs because as soon as you get that target letter, you're going to be doing everything possible to avoid charges, right? I mean, destroying evidence, whatever have you. So again, target letters are very important, but they're also very rarely used. Now, during the course of the grand jury's investigation, it may what's called run away and issue a presentment which charges criminal conduct by someone other than the target, right? So let's say they are investigating John Doe. And during the proceedings, the grand jury decides that, yeah, they're going to indict John Doe, but they're also going to indict his best friend, Jane Smith. That's a runaway grand jury, right? So the prosecutor is only asking for an indictment of one person, and the grand jury says, no, we're going to indict other people. That's perfectly fine. That's perfectly legal. The grand jury can do basically whatever the grand jury wants to do, right? And this is when they issue a presentment. It's when charges are criminal conduct by someone other than the target. Now, on the flip side, we have the arraignment, right? So when we follow a determination at a preliminary hearing or by a grand jury that probable cause exists that one, a crime occurred, and two, the person charged committed the crime, an arraignment occurs, right? So an arraignment is very similar to initial appearance, and it often occurs simultaneously. So you'll have your initial appearance and arraignment at the same time in grand jury jurisdictions. Now, it is required under the constraints of due process. Right? So thus an arraignment may include several parts of the initial appearance. Right? So when it's at bail, we might do all kinds of things. Once we said, look, probable cause has been determined by a grand jury, or preliminary hearing, the judge has determined that there is probable cause. Then you move to the arraignment where you are formally charged with crimes. You are provided official notice of the charges, and you are provided of notice of the potential penalties that they carry. Now, at the arraignment, at this point, under the Federal Rules of Criminal Procedure, Rule 10, the defendant is required to enter a plea pursuant to Rule 11. Right now, there are several types of pleas that a defendant, now that they have been indicted or that there's probable cause has been determined, they are now the defendant, can enter. Right? So the defendant may enter a not guilty plea. So this is generally what happens, right? Because you can always change your mind. You say not guilty, because then we start the investigation and all kinds of the process starts to happen. Now, generally speaking, the defendant has to say for themselves, guilty, not guilty, etc. And we'll go through the other ones in a second. Now, there's an interesting case on point, and it's what if the judge says, how do you plead? And the defendant refuses to answer. They just stand mute. They don't say anything. They just stare at the judge. What happens is we presumptively enter a not guilty plea on their behalf, right? So if they stand mute, we say we assume that you're presuming that you're not guilty, right? Again, because you haven't had anything proved against you beyond a reasonable doubt. Now, you can also plead not guilty by reason of excuse or justification, right? So not guilty by reason of insanity. Right, so this is, you are not responsible for your actions because some other factor is present. Now, that being said, when we talk about not guilty by reason of excuse or justification, the insanity plea, which we'll talk about later, is a problematic one, right? Because if you plead not guilty by reason of insanity and the jury finds that you are not guilty by reason of insanity, you don't get to go home. Instead, you go to a psychological institution, right? Usually kind of a prison type hospital, until the doctors have determined that you are no longer a threat, right? So this doesn't have necessarily a time frame on it, right? So you could be there for years and years and years. You could be there for a month. It really just depends. Now, most jurisdictions allow you to enter what's called the Alford plea, also known as nolo contendere, right? So what this basically means is the defendant says, Judge, I am not guilty, but I recognize that there's enough evidence to prove that I'm guilty. That's a nolo contendere. And what that basically is it's basically a guilty plea, right? You're basically saying, they have enough evidence to prove my guilt, but I'm innocent. Now, this is important for a couple of reasons, right? It's important for subsequent attacks, collateral attacks on a conviction. It's really important for civil matters. So let's say you hurt someone very badly, right? You break their nose and jaw or whatever, and you say, Your Honor, I'm not guilty, but I know there's enough evidence to show that I'm guilty. Now, the reason this is important is because, it's the same thing basically as a guilty plea, is civil cases, right? So if you are found guilty of a crime, the fact that you were found guilty or pled guilty can be used in a civil case, right? So if you break somebody's jaw, they can sue you for the recovery of their damages to their jaw. If you plead nolo contendere, you are saying I am not guilty, but I know there's enough evidence to show that I am. Nolo contendere pleas cannot be used against you in civil proceedings. And then finally, we have the guilty plea. So once the guilty plea is entered, now the guilty plea can be pled right off the bat. In some cases, especially if we have like misdemeanors, right? Like you're probably going to plead guilty. I'm going to slap on the wrist, or you have some kind of plea bargain. But as soon as you plead guilty, and you can plead guilty at any time, you can start off right off the bat with guilty. Once this is entered, it begins what's called the plea colloquy under Rule 11, right? And so this basically is the judge goes through a set of questions, a checklist, and in order to determine that the defendant is making the plea knowingly, voluntarily, etc., right? And so they ask, do you understand what you're being charged with? Describe to me what you're being charged with. Do you know that this carries these kind of penalties? Are you under any kind of threat or coercion? Is there any kind of plea bargain, et cetera, et cetera, et cetera? And it just goes on from there. And once the judge goes through the checklist and is satisfied that the person is entering the plea of their own volition, then the plea is accepted and the person is found guilty. If the judge can always not accept a guilty plea and instead put a not guilty plea on their behalf if they think there's something fishy, right? So judges can't change not guilty to guilty, but they can change guilty to not guilty. So that kind of gives us the idea of what it looks like when we're talking about plea bargaining and pleas. Especially we're talking about preliminary hearings, we're talking about indictments, etc. That kicks us off, right? That starts the ball rolling. So before we go to trial, right, and generally speaking, we're going to have a long time before we go to trial, we go to the most important part of the criminal justice process, right, in determining whether somebody's guilty or innocent. Oddly enough, it's not a jury trial or a bench trial. The part of the criminal process that really matters the most in determining whether somebody is guilty or not guilty of a crime, or is found guilty or not guilty of a crime, are pretrial motions, right? Motion practice is unbelievably important. So once official notification of the charges has been made via arraignment, the adversarial process at this point truly begins, right? And again, begins through motion practice. Now, the importance of pretrial motions cannot be understated because this is often where cases are won or lost, right? So consider this fact that less than 10% of criminal cases go to trial, right? So misdemeanors, almost no cases go to trial. Felonies, very few, 5 to 10 go to trial, percent-wise go to trial. And the reason that we have such a low trial rate is because of pretrial motions as well as plea bargaining. Now, generally speaking, the first pretrial motion filed, and this usually in some jurisdictions occurs automatically, is a motion for discovery, right? Basically, the defense says to the prosecution, we want any information that you have and all evidence that you have, and we want to take a look at it, right? So the prosecution generally has to turn over a lot of things to the defense. Now, that being said, the defense does not necessarily have to turn over much of anything to the prosecution. right? Again, we have self-incrimination being an issue. So motion for discovery really kind of goes in favor of the defendant. And the defendant gets to take a look at everything the prosecutor, well, most everything the prosecutor has. Some stuff does get exempt. Now, this is discovery, right? When the idea is you're discovering what the facts are, what the other party knows, etc. There's a very important case on point. Brady v. Maryland, a 1963 case. So again, during the criminal justice revolution in the United States, under the Warren Court, the court established what's called the Brady Rule. The Brady Rule requires the prosecutor to turn over all exculpatory evidence, right? So evidence is either inculpatory or exculpatory. Inculpatory means that it's evidence of a person's guilt. Exculpatory means it's evidence that the person is not guilty. Now, and I cannot stress this enough, all exculpatory evidence must be turned over. Right? Otherwise, a mistrial can occur. Otherwise, a person may be acquitted, whatever it is, via the court if exculpatory evidence is not turned over. Now, that being said, in some jurisdictions, they limit the information that can be obtained by the defendant. Right? So they may limit witness information, so their addresses, things like that, witness statements, and police officer records. Unless, and then this is true in all these jurisdictions, unless there's exculpatory evidence included in that information. If it is, then it has to be turned over. Now, the limitation on witness information, witness statements, and police officer records, here the goal is to prevent witness intimidation. But in reality, it does hurt the defense, right? Because if you can't read all police officer records, or you don't get to read all witness statements, or you don't get to know who the witnesses are, right? So that your investigator can go ask them questions. It does hurt the defense. But the whole goal is we're trying to balance the right to a fair trial with the notion of we don't want somebody out there intimidating jurors, right? Or witnesses. If I find out where a witness lives and I know their address and now I know their phone number and all this other stuff, well, I as the defendant, might have an incentive to threaten that person and change how they testify. Now, sometimes information is given to the attorney, and the attorney cannot provide it to their client, because the idea is the attorney is not going to theoretically threaten people, right? So again, it's the design is to prevent intimidation. That being said, the most common pretrial motion is the motion to suppress, right? It is basically legal malpractice if you do not file a motion to suppress, right, as the defendant. Even if you don't really have great legal standing, you still try to file a motion. You do a Hail Mary to get something thrown out. It is what it is. Right? Most of the time, pretrial motions or motions to suppress are not granted. But in some cases, they are, right? And this occurs, the motion to suppress is the exclusionary rule, right? Where police officers obtain evidence in violation of your constitutional rights. And again, this is the most common. Now, on our course page, you can click and see a sample motion to suppress, one that I wrote. And it gives you an idea of what the information is and what it needs to obtain and include. So when we're talking pretrial motions, another pretrial motion is double jeopardy, right? So as we said before, the Fifth Amendment provides defendants protection from double jeopardy by a single sovereign, right? So what this means is we have to think of the United States has 51, again, not including territories, but 51 sovereigns, right? So all 50 states are considered a sovereign, and the federal government is considered a sovereign. Now, double jeopardy applies to only a single sovereign, right? So what this means is if you are charged with a crime and the right attaches, and we'll talk about when it attaches, let's say in the state of Minnesota, and you are found not guilty, the state of Minnesota cannot bring the same charges again from the same transaction. Like if you do the crime again, you can get charged again. But that transaction, they can't bring those charges again. However, if what you did is a violation of state law, but also federal law, then the state of Minnesota could find you not guilty, and then the feds could charge you and find you guilty. Right, so this idea of single sovereign, right? We have 50 states, each are a sovereign, federal government is a sovereign, so we're only looking at single sovereigns. Now this does include the concept of collateral estoppel. Basically, if something has been found as factually true or factually accurate, in that case, it cannot be challenged or taken over. Now, the right to, or the double jeopardy right attaches when there's three portions where it attaches, right? The first is jury trials. In jury trials, the right to double jeopardy or against double jeopardy attaches when the jury is impaneled, the petit jury, the trial jury, is impaneled and sworn in. Right? At that point, double jeopardy attaches. Right, so you get swear in the jury and then immediately file a motion to dismiss, and if it's granted, nothing can happen. If we are talking a bench trial, and recall you don't have a constitutional right to a bench trial, but most states and the federal government will allow you to have a bench trial. Bench trial occurs, double jeopardy attaches, when the first witness takes the stand. Right, so as soon as that first witness is sworn in, double jeopardy attaches. Right, so attaches a little bit later than it does in jury trials, but not much, right? It's really kind of at the very beginning. So that being said, in bench trials, you get an opening statement in bench trials. Opening statement does not include double jeopardy. When the first witness takes a stand, then we have double jeopardy. Compare that to jury trials. Jury is impaneled and sworn before opening statements. All right, so as soon as that jury is impaneled and sworn, it double jeopardy attaches. And double jeopardy generally also attaches when a defendant's guilty plea is accepted by the court. Right, so after the plea colloquy, then we say double jeopardy has attached. Again, that's going to be the most common area. Now, that being said, double jeopardy does not apply when a mistrial occurs unless the defendant objects to the mistrial. Right, so let's say something procedurally went very wrong. Somebody testified about something they weren't supposed to. We find out that jurors are checking the internet to see more information about the case than they're supposed to, a whole gamut of things, right? And the judge says, okay, well, this is no longer a fair trial. You can't have a fair trial. So I am declaring a mistrial. Generally speaking, the defense is not going to object to that, right? Because that means the prosecutor has to redo the entire case. Now, one thing that's very important to keep in mind is if there is a mistrial, generally speaking, unless the defendant objects, the prosecutor can bring the same charges again, right? So let's say a jury has already been sworn in, or first witness has taken the stand, or whatever. And about halfway through, the judge figures out, oh, there's not a fair trial here for whatever reason, and declares a mistrial. The prosecutor is able to bring those same charges again. Now, in reality, how often does this happen? Not that often. Very rarely does double jeopardy issues arise, but also prosecutors don't generally like to have another trial for the same thing, right? Because trials are very expensive. And if they've already gotten a mistrial once, unless it's a really important case or a notable celebrity type case, then it's not going to happen again. They will move on. And again, this is especially true in like less severe cases. If we're talking a murder case, you can bet your butt that there will be another trial. That being said, the defendant can object to the mistrial and say, yeah, it doesn't look like we're getting a fair trial, but we object. We want to continue with the trial. Now, the fact that they object is not decisive, right? So they can object to it, and the judge can say, no, you're not getting a fair trial. I'm dismissing the case. Well, at that point, you have technically objected. The judge has overruled your objection and granted the mistrial. So double jeopardy does apply because you have objected. Now, generally speaking, if you object to a mistrial, which again, very rarely happens, the judge might just say, well, if you're okay with it, then I'm okay with it, right? So it's always kind of a dangerous game to object to a mistrial. I said very, 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 very rarely does that ever happen. Now, that being said, one thing to note about double jeopardy is it is one of the few motions subject to what's called an interlocutory appeal. Right? So most appeals occur after the jury has found somebody guilty, right? And then you appeal the guilty verdict or sentence or both or whatever. Most of the time, you have to wait, right? So say it's you file a motion for the suppression of a handgun, right, as a violation of the Constitution. And the judge says, no, I'm allowing the gun to come in. And let's say it's a very obvious violation of the Constitution. I mean, very, very obvious. And the judge wrongfully says, no, I'm allowing the gun to come in. You cannot appeal until you have been found guilty, right? Because the idea here is, well, if the gun comes in and you're still found not guilty, then who really cares, right? Like, not a big deal. So we save that generally for post-trial appeals. So once you've been found guilty, then you can appeal. There are some motions that are subject to what's called interlocutory appeals. And what this does is this stops the entire trial process until the motion is resolved or goes through an appellate court, whatever, right? So it stops the whole process in its tracks. Double jeopardy is one of these type of motions, right? Because the Constitution says you cannot be subject to the same time, basically same crime twice. You can't be put in double jeopardy, life limit procedure, etc. The idea here is it's not harmless if you've already been tried by a sovereign and they're tried again by the same sovereign for the same thing. There's stress of how that hanging over your head the whole time. Like, what if I get found guilty again? Like, what do I have to go wait in prison until my appeal takes 2 or 3 years to go through the court system? Right, like that does have some very real world consequences. So as a result, double jeopardy is one of the few motions in which we stop all proceedings. No more proceedings can occur at the trial level until the motion has been litigated at the trial level and has gone all the way up the appellate process. Once it's gone through the appellate process, then the trial can resume, assuming that there is no double jeopardy. If an appellate court finds there's double jeopardy, they remand with instructions to dismiss the case. You also have pretrial motion, the speedy trial. Now, the Sixth Amendment provides you, as an American citizen, the right to a, quote, speedy trial. Now, here's some problems. The Constitution does not say what constitutes a speedy trial, right? And so what we're going to see is we have a Sixth Amendment right to a speedy trial, but we also have a statutorily imposed right to a speedy trial. That kind of helps define what a speedy trial is. Now, generally speaking, your right to a, quote, speedy trial generally attaches at your formal indictment, the restraints of arrest or detainer if already incarcerated. Right, so as soon as they put handcuffs on you, your right to a speedy trial begins. Or at formal indictment, right, if they haven't put handcuffs on you, you just show up. Or if you're already incarcerated and they charge you with another crime, right? Immediately, that's when speedy trial begins. Now, historically, we used a balancing test based on, guess what? A totality of the circumstances in order to determine whether Speedy Trial Act or the Speedy Trial Sixth Amendment was violated. Now, these circumstances included, one, the length of the delay. So the longer it is before you get to trial, the more likely it is we're going to say that there is your right to a speedy trial has been violated. We're going to look at the reason for the delay, right? So is the prosecution the one that is delaying this by constantly filing motions for continuance and things like that, and the defense is ready to go? Then we're probably going to find that there's a violation of the Speedy Trial Act. However, if the defense is the one that's filing motions, right? The defense keeps filing motions for continuance or a motion to dismiss and has a hearing on it, whatever it is, we're going to say, well, the defendant, they could have had a speedy trial if they wanted to, but they decided to engage in motion practice. So, that's not anybody's fault but the defendants. We also looked and required that the defendant assert their rights. So the defendant has to bring the speedy trial issue to the court, has to file a motion regarding the Speedy Trial Act or Speedy Trial Sixth Amendment. It does not happen automatically, right? So it's not like we meet a certain threshold, and this is especially true with the Speedy Trial Act. We don't meet a certain threshold, and then it's immediately thrown out. The defendant, after a while, has to say, I've been in jail for this long, or I've been under indictment for this long. This is a violation of my right to a speedy trial, right? The defendant has to assert it. If the defendant does not assert it, then it can be years and years and years and years and years and years, and we won't say there's a violation of the Sixth Amendment because the defendant did not assert their rights. And we also look to make sure there has to be prejudice to the defendant, right? So this means is the defendant is placed in a position that is more likely to lead to their guilt or they're less likely to investigate or what have you because of the delay in the trial. Right, so this is especially true like when you have people who are like maybe die, like you have a witness who maybe dies and nobody took his deposition, that's going to be prejudicial, especially if they're your witness. So again, we look to see like how much prejudice, how much does it change the outcome of this case that the speedy trial was violated. Now that's what we use in terms of the Sixth Amendment, and this can always be raised, right? Sixth Amendment can always be raised. There's an easier way to deal with the Speedy Trial Act or Speedy Trial. In 1974, Congress passed what's called the Speedy Trial Act. The Speedy Trial Act required, for our purposes, two things. One, an indictment within 30 days, subject to extensions, of an arrest. Right, so we'll begin with that. If you are arrested, we require, and it's an indictment jurisdiction, we require an indictment to be handed down within 30 days. If it is not handed down within 30 days, the case is dismissed. Then, a trial must occur within 70 days, again, subject to extension, so we'll talk about that, of the indictment, right? So what you see here is basically a 100-day rule, right? A 100-day calendar. So basically you have 100 days from the time that you are arrested to have your trial. Now, if we don't reach that, if you're not given the 100 days, it surpasses it, it's still upon you as the defendant to raise the issue and show why it has been violated. Now, as I said before, the Speedy Trial Act, these are subject to extensions. So if a prosecutor files a motion, right, for a continuance, the Speedy Trial Act clock keeps ticking, right? If, however, the defendant files a motion, let's say a motion to suppress, the clock stops ticking until that motion has been dealt with. And then it begins ticking again. And the idea here is you don't want defendants just filing motions so that it reaches 100 days and then the case is dismissed. Right? So things are subject to extension based upon whom files a motion and when. Yeah, so what basically happens is a period, if the defense files a motion for continuance or a motion to dismiss or a motion for suppression, whatever, there's what's called tolling occurs, right? So we stop the clock, the 100-day clock, we stop it, and then we resume it only when the motion has been decided. And that can take months, right, to decide motions. So that's when we stop the clock and restart it. So that's where the 100 days kind of comes into play. Now, I will say this, when it comes to the Speedy Trial Act, if a defendant asserts their rights, and they are required to, right, it doesn't just happen automatically. Defendant says, oh, it's been 100 days, then something really interesting happens. This actually happened when I was working for the U.S. Coast Guard, prosecuting sexual assault cases. We had a case in which the defendant filed a complaint, grievance, or a motion to dismiss under the Speedy Trial Act. So what happened is we got one of those giant desk calendars, and we sat and we counted days, right? And we said, okay, on this date we requested this, so that doesn't count for this many days. On this date they requested this, so this still counts. On this date this happened, so this doesn't count. On this date this happened, this can count. And we just counted days from the moment that they were formally indicted or they were arrested to the moment of the filing of the Speedy Trial Act claim. So yeah, we sat over a giant calendar. And as it turns out, we had 1 day left, right? And ultimately the case had to be dismissed because we couldn't convene a jury trial in 1 day, right? So technically the motion was denied and then granted the day after, right? So it's very serious. It's very, very serious because if it's a violation of the Speedy Trial Act, it can be dismissed with prejudice, which means the case cannot be brought again, or it can be dismissed without prejudice, meaning the case can be brought again. Generally speaking, the Speedy Trial Act is going to say, and especially the Sixth Amendment, if you raise an issue under the Sixth Amendment, they're not going to be able to bring that case again. right? So it's very important that people stay up to date on terms of their caseload and their calendars, right? Now, this is kind of brings into play the problem we talked about with public defenders, right? The idea that public defenders, they carry on caseloads, maybe 500 felonies a year, right? So there's one example that I showed in my intro class where a public defender, they studied a public defender, he had so many misdemeanors and felonies that he could only spend in a year 15 minutes with a client. Now, how are you supposed to sit there and remember 100 days for each one? Like, do you go through count? And I mean, there are computer programs that now help, but it's a lot to manage, right? Because the defense has to raise it. So a lot of times the Speedy Trial Act technically gets violated, but it's never raised as an issue. Or the Sixth Amendment speedy trial gets violated and it's never raised, largely because, again, this is especially true with public defenders, that they just can't keep track, right? And if you're in prison, you're probably not keeping track because you lose a sense of time once you're inside. If you're on the outside, you might be able to help a little bit more and it might be a little different, but again, it's up to you to raise the issue. So we also have pretrial motion for change in venue. So Article 3, Section 2, the Sixth Amendment, and the Due Process Clause, right? So we have 3 constitutional provisions, requires that a trial takes place in the district that a crime occurs, unless, and now this isn't in the Constitution, but this is how the Supreme Court has interpreted it, unless the defense can show what's called actual prejudice, right? So generally speaking, wherever you commit the crime is wherever your trial has to be, unless you can show actual prejudice. Actual prejudice judges whether jurors can be objective and fair under the totality of the circumstances, right? So we look at things such as scope and nature of publicity, high percentage of jurors who are potential jurors who are aware of the crime and have formed an opinion, and potential jurors unable to objectively evaluate a case, right? So we look at these things when we say, okay, if these things are present, maybe we should not hold the trial where the crime occurred. Again, and this has to be raised by the defense. Prosecution can't do it, the defense can do it. The defense wants a trial in a different location. Now they have a right to the trial at that location, but they don't have a right to a trial in a different location unless, again, under the totality of the circumstances, they show a combination and no one is determinative. It can be, but it's not necessarily has to be determinative. Scope and nature of publicity, high percentage of jurors who were aware of the crime or formed an opinion, and potential jurors unable to objectively evaluate the case. Now, there is a case working its way through the court system now that's been working its way through the court system since I was in law school. It is an example of actual prejudice, and it's summarized in the case Arraignments. So this is the Boston Marathon bombing. So I was actually at the Boston Marathon when the bombing occurred. I was at Heartbreak Hill because I like to see people after they've run 30 some odd miles try to go up basically a mountain. That's where people like always just give up. Like it's a little kind of mean on me, but it is what it is. But that being said, I was working in chambers for the United States Court of Appeals for the First Circuit. I was working for Judge Torrea. He is the appellate court judge in the First Circuit from Puerto Rico. And what basically happened is Tsarnaev continuously filed motions for a change of venue in district court, right? So in the trial court, saying that the trial should not happen in Boston, partially because the marathon runs right past the federal courthouse in Boston, but should not happen in Boston because of actual prejudice, right? And they cited the fact that originally 2,000 jurors were sent questionnaires, right, about the case. And of that, they were only to obtain maybe 1 or 2 jurors who could potentially serve on a jury, because the people who wrote back wrote horrible things. So it wasn't just like they formed an opinion. There were some things that say hang him, put a bomb on him. I mean, just like clearly they formed opinions, right? So the Sinai filed several times and got denied several times a motion for a change of venue. So what he did then, his counsel did then, I should say, was went to the appellate court. Right now, it's not interlocutory at this point, but went to the appellate court, and it's kind of a special thing, and basically sought an order from the appellate court to order the district court to do their job and change the venue. Right. So this this motion, which I'm not going to let you or make you memorize or worry about, is a legitimate motion, right? You can go to a court and ask that a public officer be told or instructed to do their job, right? So you might recall when marriage equality was going through, the county clerk who refused to issue marriage certificates to homosexual couples, when under state law and federal law, she was required to, right? So in that case, they sought the courts to order her to do her job as a public official. And that's what basically happened in Tsarnaev. Tsarnaev went to the appellate court and said, guys, there's a panel of 3, right? You have to move the trial. Order the judge to move the trial. And the first motion that he filed with the appellate court was a 2-to-1 decision, right? So it was a panel of 3, 2-to-1 decision. And there was no hearing or anything like that. Basically what happened is the judges voted, even though my judge, Judge Treya, wanted a hearing, and said, oh, no, he can get a fair trial. We don't need to move the case. And they decided that in less than 24 hours. Now, the problem is the defense filed with their petition several, 1,000 questionnaires showing like what the jurors are saying and saying, look, I can't get a fair trial here, right? Now, is Tsarnaev unbelievably guilty? Yeah, absolutely guilty. I mean, there's no question. But this is in the United States, and you still deserve a fair trial. So what was interesting was a 2-to-1 decision, because my judge came out and said, how can we haven't had time to go through the questionnaires. We haven't had time to do any of this stuff. So the fact that the other 2 judges are saying that it's fair, how can they determine it's fair if we haven't had time to look through the 2,000 somewhat questionnaires? We haven't had time to examine this case, right? So that was right before I joined the chambers. Shortly after I joined the chambers, the defense for Tsarnaev, again, the second time, filed for a writ of mandamus, which is the order that a public official do their job. So writ of mandamus, basically writ ordering somebody to do something. Filed a second one with our court saying, look, they're still not moving to trial. This is unconstitutional, blah, 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 blah. And in this case, my judge he's a very fiery man. He's an older gentleman, but he's an awesome guy, just an awesome guy. And in this case, my judge got what he wanted in terms of a hearing. All right. So this was really an epic moment. I got to go in and actually watch it because I was in chambers while most people had to watch it on closed circuit television. Lawyers arguing, and certainly I wasn't in the room, but lawyers arguing about the merits of changing the venue. Okay? And so after the hearing, the judges voted. Okay? And it was again a 2-1 decision. So 2 of the judges said that they think he could receive a fair trial in Boston, and my judge said, absolutely not. And we came up with this conclusion. It was I think it's a very good conclusion that, yeah, look at what people were saying. Like, he's not going to get a fair trial. Yes, and we all know he was guilty, right? I mean, like, there was no question. But he still deserved a fair trial. And so we said, you can't get it in Boston. Like, look at the questionnaires. Look at what people are saying. Right? It's so highly publicized. You can't get it in Boston. If we moved it to Springfield, Massachusetts instead of Boston, Massachusetts, maybe that changes things a little bit. You're still going to be found guilty, but this is a death penalty case, and so there's a lot of factors that are present there. That's what the kind of the thought process was. The other judges said, nope, they can get a fair trial. My judge, Judge Treyer, and this is the opinion I worked on, and I've actually written some articles on it if you ever want to read them. We came to the conclusion that no, he could not receive a fair trial, not only because the jurors were all tainted, but we looked at the nature of terrorism itself. Terrorism is designed to terrify, inflict pain, victimize an entire community, right? So not just certain people, but an entire community. In this case, they inflicted, and we argued that every citizen of Boston, Massachusetts was a victim, right? Because again, everything changed. Like in the days after, everyone went on lockdown when they were searching for them. They were going house to house, conducting searches. I mean, it was a really, really weird time to be alive. And there's obviously very legally questionable things that were happening. But we said, look, and this is proof, right? We looked at the jury questionnaires and we said, look, it took them almost 14 months to find 4 jurors, right? Because that's how tainted it was. So we used that and we said, again, terrorism is designed to affect an entire community. And it did, right? We had lockdowns, we had house-to-house searches, National Guard was in the subway, like we were ordered to shelter in place. I mean, it was just all these things that continued with the victimization. So we said a victim cannot serve on a jury, right? And then that's true in every other case, right? You cannot have the victim be the juror. And so we said that everyone was a juror, and we suggested that it got moved to maybe win the other side over, say, oh, move to Springfield, Massachusetts, right? The other side of the state. And you might be able to get people who are not considered victims. So it was a 2-1 decision. We ultimately lost. Sarnaev was found guilty, sentenced to death, and now he is appealing the whole thing again, saying that he didn't get a fair trial because the venue was improper, right? And he might actually have a shot. It really just depends. I suspect, I think the only just thing is for his guilty determination to be thrown out and him to be retried in a fair jurisdiction. Now, is he unbelievably guilty? Absolutely no questions asked. But he still deserves a fair trial. That is the American way. So the next lecture we are going to look at is the admissibility of evidence in terms of, yes, pretrial motions, but also in terms of the trial. Then we'll move on after that class to the jury trial itself. So thank you for taking time to listen. As always, if you have any questions, please do not hesitate to email me. Have a good day.